Counsel. May it please the court. May I start by saying it's an honor and privilege to be here today, so thank you very much. We believe this case is ripe for further review as the Court of Appeals ruling unreasonably expanded the holdings of Goodman and Van Osdol. Now, those two cases contain limiting languages in the cases themselves, which limited their holdings to the unique situations that were presented. Now, in both cases, the parents had some agreements to pay for certain things or fund certain elements of the college education. And the district court and court of appeals simply held that it wouldn't, in this court and those final appeals, simply held that it wouldn't alter those agreements. Now, the district court and court of appeals ruling in this case, in applying those cases, expanded their holdings past the unique circumstances of those cases. So we're here to talk about post-secondary education subsidy, and that's ruled by Iowa Code Section 598.21F. Now, first, we're to determine whether one is warranted, and we do that by looking at the age of the child, the ability to attend college, the child's financial resources and whether they're self-sustaining, and then, of course, the parent's resources. Now, we stipulate that upon at least first blush, there's a reason to go on to sort of that second step, that calculation. The child here is an exceptional student. She was of age to attend ISU. She was not self-sustaining. There's no evidence she was.
But I asked a question about the record, because this is, when I read through the case and I kind of did the mental math. Now, the parties agreed that the 529, her 529 would be used for her college education, right?
Incorrect. They agreed the 529 would be used for the benefit of the children. And I think that's an important distinction. See, the 529 accounts can be transferred from child to child. And what
I thought it said each 529 had to be used for each child. That's right, because here's the reason why I ask, because when I do the math, if you take out her scholarship and then you take the 529 and divide by 4, you've got enough money to cover the sorority dues and all all the annual expenses that the district court found. That was my confusion.
And you're correct, you would, but I think in several respects that again puts the cart before the horse, and we'll get to why I say that in a moment. But no, what the parties very specifically stipulated was that the money in the 529 accounts be used for the benefit of the children. And speaking candidly about this particular case, the oldest child, Hannah, is a gifted student. She's an absolutely gifted student. The two younger ones are less so. And so it's very possible that it's going to cost these parents a significantly more amount of money to provide the same educational opportunities to those two children as it is going to be Hannah. So if we look at 598.21F and we calculate the reasonable expenses, we're supposed to calculate the reasonable and necessary expenses to attend an in-state university. The next step of that three-step process is to assess the child's reasonable ability to pay, looking at the financial resources that are available to them, things like grants, scholarships, student loans, money on hand. The third step in that order is then assessing the cost of the parents if there is a remainder that's left over. And of course, that's when we then look and see what kind of income they have. And sometimes, I would say majority of cases I read, they get a portion evenly, but sometimes they don't because one parent's a higher wage earner or has more resources. That third step, we only get there after we do the first two. And that's where this case gets interesting. A little bit of this case history. The parties were married in 95 and divorced in 2015. They produced 3 children out of that relationship. The divorce and post-divorce relationship has been contentious. I think that would be something we could all stipulate to. And the oldest child, Hannah, at issue in this matter, she and Mr. Larsen are estranged and have been since the parties split. So for a long period of time, they have had basically no relationship. That hampers his ability to have good information with regard to her financial wherewithal and the things that are available to her. Now, in August of 2016, the mother filed this action for post-secondary education because the child was attending Iowa State University. We resisted this. By our calculations, no subsidy was warranted. However, following a hearing, the district court found that both parties were to pay an amount of subsidy in the amount of $6,629.27. And the appellate court upheld that. So I see this as a two-issue case, primarily. Issue 1 is that the Court of Appeals ruling unreasonably expanded the holding of Goodman. Now, in Henry Goodman, James and Dorothy Goodman had 3 daughters, Kelly, Abby, and Molly. In 1996, they had a modification agreement where they modified their existing order, and they said that they were going to allow for post-secondary education expenses for Kelly, the oldest daughter. And in there, they agreed to pay for sorority dues and a $200 a month allowance. And conceivably, Kelly's went fine. But then when Abby, the second daughter, came to school, that's what brought this action. And when that action was brought, James did not want to pay for this allowance or for this sorority dues. However, Dorothy did. So the court looked at this case, and this court held the 1996 agreement applied to only Kelly. It didn't apply to Abby. However, this court went on to find that the parties agreed through that 96 agreement that participation in sorority life was a necessary and reasonable element of college to be considered in part of the computation, given that prior agreement. And the parties both testified they wanted their second daughter to have a similar or same college experience as did Kelly. So because of that agreement, this court found that under the unique circumstances of that case, it held that Abby's sorority dues and allowance were necessary expense for social, cultural, and educational experience.
All right, so why isn't sorority dues a reasonable, necessary expense? We've said repetitively in the cases that reasonable expenses is more than books, tuition, Make the case then why sorority expenses for those that choose to engage in that kind of activity should not be calculated,
Well, I think
not be included. I mean, I understand Goodman is stipulated facts and so forth, but stripping it away, why shouldn't sorority expenses be part of the calculation?
Well, I think there's 2 things in the record and in case law that bear this out. The first one I'll point out is the holding in Van Osdol. And in that particular case, that is the first case that acknowledged, of course, that there are additional expenses of tuition, books, and a room and board. However, what they found in that case was they assessed the reasonable fees that were estimated by the university for the average student. In other words, these are the fees Iowa State University in their financial package when they send it out said every student is likely to incur these fees, things like gas, food for their dorm fridge, etc. All right? So not a percentage of the population, every student.
Well, but when you send a child to college, you want them to experience the full gamut of a college experience, which includes, of course, attending classes and the academic aspect of it, but it also has a social aspect. Some people join sorority, some people don't. Some people do club baseball and have various expenses associated with club baseball. Some people are on the debate team and fly around to various competitions and experience expenses. But what is it that should exclude? I mean, I think your position is we ought to mark the sorority down to 0 in terms of the overall expenses.
Correct.
What is it that makes that asserted expense so unreasonable that it shouldn't be part of the calculus?
I do somewhat go back to the statute, and I go back to section 598.21F sub 2A, and it reads, the court shall determine the cost of post-secondary education based upon the cost of attending an in-state public institution for a course of institution leading to an undergraduate degree, and shall include the reasonable cost for only necessary post-secondary education expenses. Now, what the state university did, what Iowa State University said is, to obtain a degree in Van Osdol, you're going to have these additional expenses. Because you're going to have to live here, you're going to have to be. So I don't have a problem with that. I think that squares underneath the code section. But there's no part of having a sorority life that requires you to do that in order to get that degree. It's additional.
Are the sorority dues in this case, do they include room and board, living and eating at their sorority house or not?
Not in the first year, but my understanding is it would the second year. That, of course, isn't in the records. We didn't have it at the time, but that's, yeah, so there'd be, on the first year, no, they were in addition to the room and board that was assessed. I think the argument somewhat strengthens if it does include room and board and doesn't significantly increase that room and board. Because it is them, they have to live somewhere. But no, in this situation, it was in addition to what we're already being assessed for room and board as well. So I think that's, you know, I think that bears out. Now, the second thing I think bears out is actually in Appel's own brief. In Appel's brief, they cite the Iowa State website that indicated that 16.5% of students at Iowa State participate in Greek life. 16.5%. And I point this court's attention to the case of Henry marriage of Knudsen, where there was a foreign term that was to be held, and 25% of students in this particular field of study were participating in foreign term. And the Court of Appeals in that case said, that's not enough. You can get the degree without participating in foreign term. And so we have 25% is not enough, but 16.4% is enough, and that 25% is directly tied to the field of study. So I just don't think this is at all what Goodman stands for or where we should be going with this, because let's take this out to another realm. Okay, so we're now saying you can force against their will for parents to pay for sorority dues. We're going to do that. All right. We have all these cultural, educational, social experiences that need to be obtained. You're going to have to drive to them. They're spread out, especially if you go to University of Iowa. You're going to have to get to class, and you got to get to all these things, so you should probably have to buy them a car. And it's been -5 for like the last 2 weeks, so it better be a good car, or it's not going to start. And if that car doesn't start, they're going to miss class. And they're going to miss those cultural and educational opportunities. So we're going to have them buy a brand new car now too against their will?
Well, probably not, but the term reasonable and necessary expense doesn't strike me as meeting the cheapest possible approach to a college education.
Of course not.
Okay. And so judgments need to be made. And I don't doubt, of course, that there's a point at which there could be some, extravagance to beat the band.
Craziness, yeah.
I'm sure we can both come up with, tuition at Iowa State is $6,000 or $7,000, but then we could add on $30,000 for dance classes and this, that, and the other thing, or I don't know what. That all of us would say, whoa, that's just too much. But the term reasonable and necessary kind of depends. It's kind of an individualized assessment. It depends upon the resources that are kind of available. It depends upon the child, and shouldn't we? Frankly, defer to a district court's assessment of the resources that are available and what's reasonable and necessary for this particular individual. It might include sorority dues, might not in another case, maybe.
Well, perhaps, but I would say I think if we asked college students if a car was necessary for them to get back and forth to college, I think that more than 16.5% of them would say absolutely.
Well,
And that's, so I get scared if we start down that road. But to some extent, I think we need to stick to the statute a little bit too. I think that if we start having district court judges tell parents, these are the things that you should value in your kid's education, we really open up Pandora's box.
Well, isn't the child sort of setting the stage and not the court? Hannah wanted to be a part of the sorority, right?
And she can be, absolutely.
So it's
Just pay
not
for
the
it
court taking the lead here, it's the interest of the child that should control this decision, including the parents' child's pursuit of her college education.
Well, while the child may have taken the lead to want to be in a sorority, the court took the lead to make the parents pay for it. And that's what we're here about. We're not here about whether she can be in a sorority. She can be in a sorority. I was in a fraternity. I paid for it. That's the way it works. But where we take offense is that a judge can tell somebody you have to pay for your daughter's sorority dues, whether you agree with it or not. And that is certainly 15 steps further than Goodman ever
Can't
went.
we take that into account in the next phase of the analysis, as you put it, the phase where we figure out what she's expected to be able to contribute towards her education?
We can.
In terms of summer earnings and part-time work and savings?
We can, and run short of time here to get the issue too, but essentially in Van Osdol, the issue in Van Osdol is they didn't assess student loans. And so our court in this particular case didn't assess student loans to her reasonable ability to pay. And my problem with that is that once again in Van Osdol, there was an agreement. Neither one of them asked for the student loans to be assessed. And so The only reason they weren't assessed was because of that agreement. Now, I would tell this court there are 26 cases on Westlaw that cite Iowa Code Section 598.21F. And I read every single one of them in preparation for this particular oral argument, and not a one of those cases did the parents ask their student loans to be assessed, and they weren't. This would be the first case. Because the reality is that's step 2, right? And before we assess costs as parents in step 3, we have to go to step 2. And my problem is I believe we skipped a step in this case, and I see that I'm out of time.
Mr. Carr, thank you. Ms. Facio.
May it please the court. My name is Nicole Facio. I'm the attorney for Miss Larsen, who is now Miss Jones. And I think it's a widely held principle that there are many costs to a college education, and this court, the district court, the Court of Appeals have all held several times that a college education includes social, cultural, educational experiences that add to the cost of attendance. And as any parent knows that's sent a child to college, including myself, you can't just look at tuition fees, room and board as the cost of an education, a college education. And before I defend the inclusion of sorority dues or a cash allowance, I want to encourage this court to take a somewhat different approach and help us at the district court avoid a lot of the litigation about these issues and simply look to the estimated costs that the institutions themselves provide us in terms of what is the cost of a college education. And every institution in Iowa includes an estimation of costs. They're made public. They include some allowance, cash allowance or personal expenses, costs for books. And this would avoid these judgment calls about what is a reasonable or necessary expense. Is sorority dues appropriate? Is, in another case, science participation or marching band? I'm sure those have costs in terms of travel and other expenses, instrument expenses, and we avoid that those litigation by just simply using the estimate that the college provides to us every year and increases over time when tuition and inflation goes up.
All right, say hypothetically we agree with you on that, then would you agree that if there's going to be some flexibility then on the cost side, that is, the cost will include more than just strictly tuition, room and board and books, but will also include some of these other costs that undoubtedly people incur? Shouldn't there also have been, in this particular case, some attribution of some amount of money that the daughter was going to earn while she was attending college, right?
Well, I think that's a separate analysis, or as Mr. Carr put it, step 2 of the analysis in terms of what she can contribute. In terms of the expenses, most colleges, all colleges, have a cushion or have some expenses for personal expenses that include, I think they anticipate transportation, we have clothing, other kinds of expenses that a child might have. And then the second step is to look at what the child can contribute, but avoiding the judgment in terms of whether sorority participation is a valuable experience or not, and we can just look at what the estimate that the college uses and provides to us. In this case, we ended up arguing, or the district court used actual expenses because we were sitting day 1 of the semester and we actually had those. Sometimes you hopefully want to have a hearing sooner. We don't have actual expenses. And we were arguing about, or having litigation about, books $588 versus $600, or $87 in fees for one semester that weren't going to be.
Well, we won't worry too much about that, but let's worry about, I mean, there are cases at least that suggest that a student, certainly in the summer, can earn a certain amount of money. Now, but, you know, how much, query, but some kind of summer job. And I think there was testimony in the record, and I know you'll correct me if I miss it, but something to the effect that a 10-hour job at kind of a low wage, maybe $750, might have been available during the school year, maybe. But the bottom line point is on step 2, ordinarily, a college student is expected to contribute something. And if I understand district court correctly, it was 0 in this case.
Your Honor, first of all, I think the testimony was that on that day, she didn't have employment, but had been offered a 5-hour-a-week at $7 or $7.25 job, which I think is pretty minimal in terms of that. And I don't agree that the district court said she had no contribution. This child, as Mr.
Oh,
Carr.
in contribution in terms of earned income is what I'm driving at. I mean, summertime,
She's still going to be responsible for up to a third of the costs, and much of that doesn't include other costs, such as she had a car that she has to pay for and that kind of thing. But I think she's still going to be responsible for a third of the cost that her scholarships did not take up. Or
about the loan issue,
Your Honor, I think we're sitting in equity in this case, and the facts of this case is a little bit unique in terms of the aggressive savings that these parties participated in. This court has held that the purpose of this statute is to ensure that a divorce doesn't become a financial impediment to the child's college education. And in this is what's happening in this case. The parties during their marriage aggressively saved for college. We had 529s for 3 children, over $155,000.
unless you buy the notion that, okay, so there's 60,000 or 63,000, I'm not sure how much,
63 for this child.
63 for this child. And then you have 2 other children that have lesser amounts in their 529s.
Because they're younger.
Yeah. The suggestion was made in response to Justice Mansfield that, well, some of that 60 maybe could be transferred to the other children for their benefit, and therefore we should be studying this kind of closely in order to enhance the funds of those that are coming.
Well, we can always guess at what the other children will need. I don't know. They're not even.
What does the
Can I-
record show?
Yeah, I mean, could I just get a clarification? I apologize. I just wanted, is it your understanding, do you read the original decree the same way? That is, that the 529s are to be used collectively for the children, but there's no obligation to use one 529 for one kid?
Unfortunately, was my drafting in that agreement, and I believe the intent was that each child had their separate 529 account, and that those would be used for those children and not withheld from those children. In anticipation, at the time of the divorce, Mr. Larsen was a stranger, had a difficult relationship with 2 of his children, and so that the anticipation or purpose in writing that was that it would not be held from that child. And that, I don't know.
Each child will get their own, because frankly, that's the way I read it until Mr. Carr explained it otherwise.
That was my intent in drafting, and that was the agreement, my understanding of our agreement, that each child had their own. They weren't on a collective account. Each child had their own account. And it is a concern to me in terms of the other case law. We don't have the presence of this large significant asset that is available to use for college education. And it's inequitable to this child and to my client to allow Mr. Larsen to avoid using these funds, which was a significant asset in the divorce, simply because he now is divorced and has a difficult relationship with his child. If the parents were still remained married and we had this 529 account for the child over $60,000, I don't believe that the parties would be making this child get a loan. So that even if they had the money sitting there, they would still require her to get a loan. And the purpose of the statute is to avoid those kind of consequences for children of divorce, not allow them to
What's going to happen
happen.
with this account then? How do we factor this account into the overall college education expenses for this young lady?
I think that's a good question. Ms. Jones had initially requested the court that this account actually just be transferred to her daughter now that she was 18 and could be owner of the account, and she used those funds to fund her college education, and both parents just be absolved of their obligation, because I think one of the justices pointed out the math in terms of what their obligation might be over 4. This child anticipates 5 years. And it roughly equates to what the college education account was. And so we had advocated that the district court take that approach and just transfer this account into the child's name, or have her use that for her expenses and absolve the parents. I think these 529 accounts can be transferred for other children. I think that they all should be cashed out. Now, our agreement, to me, indicates that that's not allowed, that they have to be used for this purpose, for educational purposes, and for the children. So I don't think it would allow Mr. Larsen to cash it out, even with a penalty, but
But what's to say that we've got $63,000 for this young lady? What if we just say that we're gonna take 10,000 of that for each year and deduct that from the overall college expenses and then make the division of 3? I mean, there's so many different ways you can cut this up, which I don't know why or how exactly, this court's going to figure that out, but why can't we factor that in and just say, well, we're gonna set aside 10,000 and take that right off the top, so now we have 7,000, she's got loans to cover hers, the other 2 have money, and we're done, and there's plenty of money and she can do whatever she wants to as far as sorority or every other extracurricular activity. Could we do that? Could a district court judge do that?
I believe they could. I think it would, and sitting in equity, I think there's been another court case, the Court of Appeals published case Kuferschmidt, I think, where it dealt with uniform transfer to minors accounts, and that court looked at those accounts being used as the child's resource. And when the court considered what the child can contribute, they looked at those accounts, attributed it to the child. Those accounts even were transferred after the children turned 18 into their name, similar to this situation, and that was considered the child's contribution to the expenses. I would advocate, I think, makes sense to me, and I think it's fair to the parties when they had an implicit agreement during their marriage that they were going to save aggressively for their children, and they did that by putting it in a 529 college savings account, clearly indicating their intent to help out with their children's education, and then had an explicit agreement in their divorce decree that that was the purpose of these accounts. And now it's inequitable to allow Mr. Larsen to withhold those funds or to argue that his child should have to take loans when those funds are sitting there and available. And a decision does have to be made about how to deal with these 529 accounts in divorces. I struggle with being involved in this case from the beginning and writing the language. This was a $155,000 asset in this divorce. And how do we attribute that? My client was concerned about this very outcome, but having her give up a significant amount of asset or having to exchange equity in a house to make sure that these funds are used for her child's education, I don't think is fair to her either. So that it was an attempt to be a compromise, but we're sitting here today to have litigation about it still. I think if the court goes in terms of case precedent as Mr. Carr, in terms of any time a child is eligible for loans, that they should be considered and they should be taken, the purpose of this statute loses its effectiveness because in this day and age, a child can fund their entire education with loans. We have government loans, we have private loans, and if the requirement is that they have to take loans if they're available, even though equity suggests otherwise, the statute becomes ineffective. So I advocate that we first take a different approach into estimating the cost of expenses. We use the university's approach. And second, we come up with a way to deal with these 529 accounts. I think Justice Zager, has a good approach in terms of maybe considering these as the child's contribution towards their education and using those and determining what they can contribute or what the parents should contribute. Most of the case law that says loans have to be considered or that the child has to contribute more have parents that have limited resources. And in this case, the parents have the resources to pay for the education. They have not even they make good incomes, but they have set aside a significant asset for this purpose, and that purpose should be executed in terms of using these 529 account for the purposes of this child's education and not incur additional loans and harm her.
The problem with that, I mean, it sounds like good policy, but then, under 21F2B, statute says, the court shall then determine the amount which the child may reasonably be expected to contribute, considering the child's resources, including but not limited to financial aid, whether in the form of scholarships, grants, or loans, and the ability of the child to earn income. It doesn't say anything about the parents' resources at that stage, right?
Well, I think that is true. And when the court, and it says considering all of the resources, the difficult nature of these 529 accounts in terms of them being owned by the parent and not the child, as opposed to the Transfers to Minors Act, or if we had in the old system where we put money aside for in custodial accounts, is that it's really not a child's resource. But in fact, in reality, the parents have set that aside. The child is named as a beneficiary, and it could be considered as a possible resource. I think the greater problem is the inequity that occurs when parents have this asset. It was divided in a divorce, and it's then withheld for the very purpose that it was saved for. Thank you.
Ms. Facio, thank you as well. Mr. Carr?
I want to start off by piggybacking off of what Justice Mansfield just said. In Van Osdol, they talk a lot about what the legislative intent was in forming this particular statute of 598.21F. And they talked about how the legislature could have specifically limited it to books, tuition, room and board, but they chose not to, so we'd allow those extra expenses. What the legislature also could have chosen to do was to take Justice Zager's idea and say, well, before we even start deciding whether the child has the ability to pay, let's see if the parents can just fund the whole thing. And if they can, well, that's step one and we're done. But that's not how 598.21F is drafted. 598.21F gives us a very specific three-step calculation. We cannot start with step 3. The legislature intended us to start with step 1 and determine what the costs are, to go to step 2 to determine the financial resources available to the child, and step 3 to determine if there's a remainder, and then apportion that to the parents in an equitable manner, and that's where the equity comes in.
Well, let's face it, the legislature hasn't even thought this far through when it talks about these accounts that we're talking about. From my experience, you're in a very, very unique situation where they actually did aggressively save for college, do have these accounts. That's probably a very small percentage of children who are subject to divorce and subject to this type of code provision that we are now arduously going through to try to figure out what's fair. There's no mention of these accounts anywhere in this statute, and obviously that's a critical element. When you have a $63,000 asset here that's available for that specific purpose of post-secondary education subsidy or post-secondary education expenses, but it's not mentioned anywhere in the statute. So somehow, what are we supposed to do with that? It's an asset that's there. You can't just ignore it and say, well, the legislature didn't think about that because you're in a very unique situation, so we just ignore it. Somehow it's got to be considered. Wouldn't you agree?
And it is considered in step 3. Ultimately, what happens is in step 3, if one parent has significantly more assets than does the other, then oftentimes they are assessed a higher responsibility. So when we talk about where equity comes in and where we decide whether the parents had the money or not, it's there. It's just not until we do the first 2 steps. In the legislature, we've had 529 accounts around for a very long time. They've known about it. If they wanted to switch this statute, they certainly could have. But they haven't. And we are bound to follow the statute. And what the statute tells us is we can't get to how much money the parents have until we get to step 3.
Well, let's talk about the
steps.
loan business a little bit, because I think it's,
I'd love to, thank you.
yeah, well, I mean, it's a significant part of the case. The argument contrary to your position as well, any college education can be fully funded by loan. In fact, there are people out there happy to make student loans. You could be attending the $70,000 a year school, and loans are available. Now, is the student required to take out all available loans as part of the student contribution in step 2?
No, I think the loans that are offered by the school are certainly from the state institution, because remember, we can't get a $70,000 private college here. So at the state institution, they will always put on there whether you're eligible for some federal subsidized or unsubsidized loan, and those are what uniformly we see in these cases that come before the court. And I think those are to be imposed. Now, if we start off on there's another loan that was listed on Exhibit C, which would have been like a private loan that she would have been able to take out with her family and things of that nature. That is sort of a mixed resource of the child and the parent. And I don't think there's any case law that would suggest we have to make them take that out.
Okay, fair enough, this is helpful, thank you. But why would we have, require a child to take out loans when the assets in the 529 account are sufficient to pay for the education?
For the reason my client said, he wanted her to have some skin in the game. It was his parental point of view, always, he said, even while I saved, to have her have some value in her education, to have her pay some money for her education so that she had value for it. That is a parental right to have that be something that he values. And the statute protects that if we apply it appropriately. There are people all over the place. Myself, I'm a son of a doctor. I graduated from Drake University with $165,000 of the student loans. My dad made me value my education. That's okay. That's a parenting decision. And the statute allows for that.
Well, except the parents, prior to divorce, made the decision to save $63,000 for the education of this child. Doesn't that suggest that the $63,000 ought to be spent for the education of the child? 63 divided by 5 years is, somebody help me?
Well, again, I see I'm out of time, but to go back to the original thing, if we read the decree, it tells us what we're going to do with that money. The decree tells us the parties are free to continue to add funds to these accounts, but are not required to do so. However, the balances of each of these accounts should not be reduced below half of the amounts unless due to market conditions. The parties acknowledge that these accounts are for the children, not each child, the children, and will not be used for any other purposes or withheld from any of the children. The parties shall exchange statements on April 1st. Simply put, these are transferable. We could have said, four corners of the decree is how we look at a decree. The decree could have said it's for each individual child. It doesn't say that. So, Your Honors, we'd ask that you, based upon our calculations that we are in our chart, find that there is no post-secondary education subsidy warranted in this matter as a child is able to self-fund their education. Thank you.
Carr, thank you as well, and Ms. Facio, thank you. The case of in re the marriage of Lynn and Roger Larsen is now then submitted, and the bailiff may adjourn.
Hear ye, hear ye. The Honorable Supreme Court of the State of Iowa is now adjourned.